Thank you and good afternoon, everyone. I'd like to call the meeting to order. This is the California State Board of Optometry, Consumer Protection, and Public Relations and Outreach Committee. And we'll go ahead and confirm that we have a quorum. Dr. Turetsky.
I am here. Hi, Sid. Hi, Jeff.
Hello, and Dr. Garcia.
Present. Thank you.
Okay, it appears that we have a quorum. And our executive officer, I am hoping, is still on. I can't see the whole band, unfortunately.
Yes, I am still on. If you want to try to choose the layout button and then just block out those who don't have on video, it might be a little bit better for our discussion.
Great, wonderful, thank you. And I'd like to turn to the public for any comments or items that are not on the agenda.
All right, this is the moderator. At the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a public comment for items not on the agenda, please click on that question mark or the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. Currently sharing instructions on the screen for your reference. And in the ask field, and typically in the lower right-hand corner of your WebEx screen, please type I would like to make a public comment and send to all panelists. And it appears at this time there are no requests for public comment. Would you like me to close that Q&A feature?
Please, moderator, if you could close that feature.
All right, the Q&A feature is now closed.
Thank you, and I'd like to move on to agenda item number 3, discussion of possible action on our minutes from the July meeting. We had a different composition of the team at that time, and therefore I will turn to, first of all, my colleagues on the committee to see if you have any questions or comments.
This is Dave. I was there. I read the minutes and they look correct to me, but I believe that if there's a procedure, right? If we can't establish a quorum to vote on this.
That is correct, but there isn't a need to have attended the meeting to approve the minutes. If you have read them and they appear to be factually true, information that was given to you at the resulting board meetings coincide with the information available within the minutes, then you may each vote to approve them here today.
Okay, thank you. Do I have a motion to approve the minutes?
This is Dave. I would motion that we accept the minutes.
And this is Jeff. I'll second that.
And any comments from the public?
All right, this is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Once again, members of the public, if you would like to make a public comment on this motion, please click that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, this is the moderator, and it looks like at this time there are no requests for public comment. Would you like me to close that Q&A feature?
Thank you, moderator, please.
All right, the Q&A feature is now closed.
Thank you, and go ahead. We have a motion on the floor, and I'll call for the roll call. So to approve the minutes, Dr. Turetsky?
Aye.
Dr. Garcia?
Aye.
And I myself. So the motion carries. We'll go ahead and move to agenda item number 4, discussion and possible action on meeting minutes from January 31st of 2020. Do I have a motion on the floor?
I motion to accept the meeting minutes from January 31st, 2020.
Do I have a second?
I second.
Thank you. And any comments from the public, please?
All right, this is the moderator, and at the direction of the committee, I've opened up that Q&A feature for public comment. Once again, members of the public, if you would like to make a comment on this motion, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. And at this time, it looks like there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please, moderator.
All right, the Q&A panel is now closed.
Thank you, and we'll go ahead and take a roll call. Dr. Turetsky,
Aye.
Dr. Garcia,
Aye.
and I myself, so the motion carries. We'll go ahead and move to item number 5. And for this one, I will turn it over to our executive officer to discuss Assembly Bill 458. And I would just ask for those of us who are not speaking, if you could put your microphones on mute. We're getting some feedback. Thank you.
Excellent. You'll all recall that we worked on this bill in 2018, 2019 with Assemblymember Nazarian's office. This was a carve out from the very many years previous discussions regarding mobile practice. This allows optometrists to apply for a certificate that enables them to do in-home care. The bill has been worked on primarily by our policy analyst and Dr. Turetsky. So I'll go ahead and have Mark Johnson take up the presentation at this point.
Okay, thanks, Shara. So this regulatory proposal, as Shara mentioned, implements Assembly Bill 458, which amended Business and Professions Code 3070.1. I did work on this with Dr. Turetsky, and I'm grateful to him for his help through this, and also with our regulatory counsel, Danny Rogers, who is on the call here today. To keep kind of short explanation what the bill does. The BPC 3070.1 authorizes a TPA certified optometrist to practice optometry in the residence of an individual who is unable to obtain optometric services outside of their home due to a disabling mental or physical condition. The optometrist has to complete an application with the board, pay fees, and also agree to meet certain record retention and patient disclosure requirements. In addition, the optometrist is also, according to the bill, required to provide a patient notice prescribed by our board, and also to provide an authorization, which I believe is optional if the patient wishes to release the medical information, the patient's medical information to the board for enforcement purposes. So this proposal creates a new section in the California Code of Regulations, Title 16. It's section 1507.5, and it's also going to amend existing section 15.4, which refers to fees. 1507.5 does the following. In full. It creates an application, initial application for a home residence permit. It creates an application for renewal of the home residence permit. It sets out requirements for the patient notice to be provided to the patient, and also requires an acknowledgement that the patient has received it. And then it also allows, again, the release of the patient's medical record to the board for enforcement purposes. Within 1524, which is our fees section, it does set an application fee of $50, which is paid when the optometrist applies, a renewal fee of $50, and then a delinquent fee for that renewal of $25. Any questions so far? Okay. So if you move to attachment A, this is the proposed text for the implementation of Assembly Bill 458. I'll just go through and just refer to each individual section and just open it up if there's any comments or changes that the committee might have. Subsection A is the section that would implement Business and Professions Code 3070B1, which requires the initial application to be made via form. Kind of similar to what we did with Assembly Bill 443, which is the Immunization Authorizations. We put the form's requirements within the regulation because I believe it's our intention to have this form available within Breeze. And so putting the requirements of the form into regulation allows us to do that, so we don't have to incorporate a form by reference. We still can use, if we want to create a paper form, we still have the flexibility to do that with this. The form requires just some fairly standard information: name, address, phone number, email address, license number, etc., and then a declaration that the applicant that the information that provided is true and accurate, and also a declaration by the applicant under the penalty of perjury that the applicant will comply with all the state and federal record-keeping requirements and other requirements that are set forth within 3070.1. Any questions, thoughts? Okay.
None.
Okay, thanks. Subsection B is essentially the same as subsection A. It implements Business and Professions Code 3070 B2, which requires the renewal application to be made. It's very similar to subsection A. Any questions or thoughts about this one? Any discussion or changes?
Mark?
Yes.
Hi, it's Dave. Just a few basic questions on this. And I'm not sure. Well, I'll put out my comments and you tell me. And these are questions that I brought up before. So the consumer notice, I know it has to be 14 points. Is there a size on the notice that has to be specified? 8 by 10, 11 by 15? I mean, is there anything that mandates that?
No, not that I'm aware of within the bill, no.
As long as it's 14 point, it's okay?
Yeah, and I just put 14 point. It's kind of a common size, but certainly if we want to change that or specify it further or whatever, we certainly can do so.
Well, I mean, I don't know if it could be made smaller, if that's permitted. I have no idea. I know that there have been instances where the Department of Managed Healthcare would find an entity because they printed it in a size print which was not specified in the regulations. So whatever we do, we're pretty much going to be stuck with it. My concern from speaking as a business owner, as you know, my group does nursing home vision care, and we would fall under the need to provide a consumer notice to our residents. We wouldn't necessarily have to get the signatures, but we'd still have to provide the notice. We see 50,000 patients a year, which means we'd be giving out 50,000 pieces of paper, and we are supposed to be making every effort to cut down on the use of paper and make things a little greener. And this is definitely not going to do it. Would it be legitimate for us to have the consumer notice as part of our prescription pad? So we might give out a prescription that's 8 by 10 and have the notice below the prescription itself? Or is there any regulation as to how we have to present that notice to the patient?
Well, to your first point about the volume, I mean, when we were working on this, we did slide in a provision that allows the consumer notice to be issued in person or electronically. So that could be done via email and such like that.
Unfortunately, in many instances, we're dealing with folks who don't have access to email or dealing with locations that are so bombarded with email that they will be unwilling to have additional emails sent to them. So it's an interesting issue for very few optometrists that are dealing with entities that my group deals with, and the other couple dozen optometrists that do similar work.
Sure. That's a very good point. And then your second question regarding putting it on the back of a prescription, everything like that, I did note there. I'm wondering if Danny Rogers, our reg counsel, might have a little more input, if that would be permissible. It seems like it would be, but I'm not 100% sure.
Hey, David, I have a question on your question. So looking at the consumer notice, it says it can be provided to the caregiver. So if these patients are in a nursing home, the caregiver would be the nursing home, correct?
Correct. It would be the social services director of the facility.
So it looks like the way it's written, you could give one notice to the caregiver of that facility and be covered.
But that, if you look at one of the notes that's on the side, Mark did ask our legal counsel on that, and it sounds like it has to be one notice per person instead of one notice per facility.
Okay.
Because your point is exactly my point. Is that wouldn't that be a little simpler? One notice for a facility?
I have a question on that. If more and more doctors' offices are turning to electronic tools such as an iPad or something similar to check in their patients and the like, if we were to enable something like that to help, to Dr. Tereski's point of cutting down on paper and being a little bit greener and sustainable, are we able to have an electronic application, if you will, an electronic notice that they sign electronically, and then that gets registered somehow into Breeze ultimately, or wherever it needs to go?
So unfortunately, and this is Shara, we are constrained by the statute, which requires that it be issued to each patient. And you'll recall from our lengthy discussions, right, we're often dealing here with a more at-risk population. We want to make sure that they have an easily referenceable, notice that gives them information on how they might complain about services or how they might file a complaint. So I think that we come down to here, Dr. Tereski, you've got a great idea. I put on the back of your prescription. And no one says it has to be 8 by 10 or 11 by 14. It's just got to be 14 point. And that, unfortunately, in this particular situation, as we went through discussions with the legislature, it really was important, we felt, to have something given directly to that more at-risk consumer in order to make sure that they have that consumer notice information available in order to file a complaint if needed.
Okay. And I have one more comment, just a general comment on this. Once the regs are approved and everything is out there, will the board be sending out a notice to an email notice to all ODs to take a look at this? Because I know there are people that are interested in doing home examinations, and they, instead of doing it illegally, they should know that there's a legal way to go about getting a permit for this.
Dr. Tereski, do you say that you're aware of unprofessional conduct? I know that's not what I heard.
I have heard rumors.
No, we know that, we know that currently, of course, doctors can provide treatments using temporary hours in order to provide specified service for particularly at-risk individuals, but we really did want to make sure that this can be a practice model that folks are able to use with aging Californians. And so I know that there are some folks who do use their temporary hours in order to give specialized treatment. And yes, of course, this would be a part of our regular communications. And if there were, once we do get the regs off to AOL, if this body, as as a team that looks at communication, wanted to give us particular directives or thoughts or suggestions, we of course would love that. But it would be, of course, be a part of our president's message, posted on our website, go out to our listserv, and then also be done as a social media campaign on our social media channels.
And I'm going to just say one thing too. This this regulation really isn't just for senior population. We're also talking about a lot of folks who are potentially disabled and transportation is difficult. And this will open up a whole lot of new care options, because I know there are ODs out there that will go to places but are afraid to do it right now because of insurance or legal issues.
I certainly agree with you. I think it was very insightful on the part of the board to pull this carve out of the mobile practice in order to provide this sort of the specialization in care. Kudos to the board.
And to Dr. Nazarian, Assembly Member Nazarian, for supporting this.
Any other comments from staff or the board?
I think, Sid, I just would like to direct members' attention to subsection C, the consumer notice that we've been talking about, but I just wanted to see if there was any other changes or additions or subtractions from this section.
And I'd like to open it up for public comment too. And maybe we can do that so that we circle back through the board comments.
All right, this is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, this is the moderator, and it looks like at this time there are no requests for public comment. Would you like me to close the Q&A panel?
Yes, please, and we'll bring it back to the board for discussion. Okay. Those were some of the key call outs that were in the draft that were sent to us. Are there any other items that we wish to surface as comments at this time? Dr. Garcia, no.
None.
Doretsky?
I think I'm good right now. Thanks.
Okay, any close-out comments from staff before I raise next steps?
I have no more. Thank you, sir.
Our executive officer? No, okay, thank you. All right, so to take action, we're looking at bringing this to the full board potentially. And my question is, if we want to bring these suggested edits and also potential amendment, if you will. So do we, for the executive officer, do we need a literal vote, or is this a thumbs up, thumbs down? Okay.
It would be great to have a vote from the committee and saying that you all endorse this language and are bringing it as a committee to the full board.
Dr. Turetsky?
I would motion to accept the draft regulations as written and forward them to the full board for approval.
With a friendly amendment to bring the comments as well that are on the draft, because other board members may be thinking the same thing.
I second that with the friendly amendments.
Okay, we have a motion on the floor and a second, so we'll go ahead and take a vote.
Public comment?
Oh, sorry, thank you. Go back to the public.
All right, this is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this motion, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll pause a moment to allow the public time to access the Q&A panel and submit their requests.
See any?
All right, it looks like there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please, moderator.
All right, Q&A panel is now closed.
Now we'll call for the question and the vote. So Dr. Turetsky
Aye.
and Dr. Garcia,
Aye.
and I'm an aye. So the motion carries that we will be bringing this attachment together with its comments to the full board. Thank you. And now we'll go to agenda item number 6, scrolling. And that, again, is discussion and possible action on Assembly Bill 896. So I'll turn this over to staff and Executive Officer, if you would like to take it from here.
Excellent. So folks will recall our negotiations with stakeholders, particularly Vision to Learn, and with the help of Assemblymember Lowe, his authoring the bill and then shepherding discussions and negotiations as we went through the legislative process. So this does allow mobile practice for nonprofit organizations. These are the regulations that will implement and allow us to track reporting from the entities that choose to apply to be a corporation that provides mobile units, just making sure all the process is correct. And we, of course, within the legislation have a charge to complete this regulatory process before the end of this year, so that regulations are enacted by 2022. With that, I'll let Mark move into the substance of the bill, and of course, available if there are other questions. Or I'm sorry, the substance of the regulatory package, and then of course available if there are any other questions.
Okay, thanks, Shar. So this proposal, as Shar mentioned, implements Assembly Bill 896. The bill was signed into law last fall, and the regulations are required to be implemented by January 1st of 2022. So, our hope is to get moving on these pretty quickly. Right now, as this is presented, it is considered kind of a draft proposal. Unless the committee or Shar feels otherwise, I'd like to take comments on our proposal and then work on it internally, and then perhaps have the committee review it again at a future meeting in the next month or two. Our legal folks are still kind of working through this draft as well and have not provided substantive comments on this. So if that's okay with that idea going forward, I'll move into the substance of the regulation. Okay. So 896 does a couple of things. It defines what a mobile optometric office is. The statute says that it means a trailer, van, or other means of transportation in which the practice of optometry is performed and which is not affiliated with an approved optometry school. The bill limits ownership of the mobile optometric office to a tax-exempt nonprofit or charitable organization that provides optometric services to patients regardless of their ability to pay. The bill requires the owner and operator of a mobile optometric office to register with the board and provide specified information. It prohibits the owner and operator from accepting payments for services other than those provided to Medi-Cal beneficiaries. It does require the owner and operator of a mobile optometric office to file a quarterly report with the board and also provide a consumer notice to each patient. It requires us, obviously, to establish regulations, establishing the registry and also set a registration fee. It does require the owner and operator to maintain records and make them available to the board upon inspection. And for the individual optometrists that provide care under this law, they are required to be TPA certified and also obtain a statement of licensure with the owner and operator's addresses registered with the board. It shouldn't say mobile optometric office. It should say owner and operator. So that's in a nutshell what the law requires. Any questions or comments early on?
Dr. Garcia, any questions or comments?
Yeah, I have a kind of a general question. So for optometrists that do homeless clinics, for example, in the community that aren't on a mobile clinic or a van, and they're not necessarily in a home, does that fall under either one of these?
No, it does not, Dr. Garcia. So this bill was narrowed for only those operations that are only those clinics that are operated in a van, vehicle, or mode of transportation. So a community healthcare event or like stand down event, those do not typically operate in vehicles and so would be outside of the law.
So that would fall outside of 458 as well?
Yes. So those remain not authorized by law.
Thank you. Thank you.
Shara, it's Dave. So on Jeff's point there, okay, so you do a homeless clinic where there's podiatrists and an optometrist and all types of professionals, and it's not in a van or mobile or something on that order. Could that optometrist theoretically be cited for practicing outside of the law, outside of the regulations?
So of course we crafted, or we worked with the author's office to craft this so that an optometrist can still use their temporary hours of work to work with a nonprofit. But if it goes beyond their temporary hours of work, if this is an employment situation or an extended service situation, if it does not occur inside of a vehicle, that optometrist could be subject to an enforcement case and possible discipline.
My concern is, and I don't know if we have a responsibility or if it's the individual optometrist's responsibility, but you know, I know Jeff has done charity events before. I've seen his resume. I've done charity events before. Theoretically, if we were working outside of the law, if there was a professional liability action that was taken and you're performing something outside of the law, your insurance carrier isn't going to cover you. I mean, this has a tremendously detrimental effect for people that are trying to do good within their community. And I don't know how we go about correcting that. Do you have any thoughts on that? Anybody? Don't everybody speak at once.
Yeah, David, that was Jeff Garcia. That was kind of my concern in a roundabout way, because I know that a lot of optometrists do those sorts of things, but it doesn't fall within these two bills. So and then Shara kind of clarified that it doesn't fall cleanly within these two bills, but it's still not illegal as long as it's not set as an ongoing business practice. Is that the guideline?
I heard temporary hours of work, and I wanted clarification on what exactly temporary hours of work means for a doctor who likely does work outside of 9 to 5, sitting in their office if they need to call back a patient or something like that. So can you explain temporary hours of work?
Certainly. Give me just a moment. I'll pull up the law book so as to be sure that I express this appropriately and don't add any particular nuance that might be incorrect. So just as within 458,
And then I'll have another follow-on question.
So we are in 3070, I'm sorry, Business and Professions, section 3070 B. A licensed optometrist is not required to provide the notification described in subdivision A, and that is notification for a home permit. If he or she engages in the temporary practice of optometry. Temporary practice is defined as the practice of optometry at locations other than the optometrist's principal place of practice for not more than 5 calendar days during a 30-day period and not more than 36 days within a calendar year. The limitation shall apply to all practice locations where the licensed optometrist is engaged in temporary practice, not to each practice location individually. If the time period of the temporary practice needs to be extended for any reason, the licensed optometrist shall submit an application for a statement of licensure to the Board of Optometry.
Okay, that
That
helps.
helps.
So,
Okay,
So-
so along those lines, are we then suggesting if our optometrists would like to serve their community, that potentially they would need a tax exempt nonprofit status if they didn't, but they are not that regularly, they're a for-profit. I mean, how do we reconcile this if one of our doctors wants to be in a mobile optometric office that may or may not be owned by their practice, and yet at the same time they want to do good? Yeah, I'm just trying to reconcile all this, because I agree with our doctors that this kind of potentially closes doors at the same time that it opens them. And I don't know if we lost Dr. Garcia. We may have just lost him on the camera.
Well, I do have a question for Jeff. I do have a question for Shara. I'm looking at what you just read on 3070. It was my understanding, and it could have just been my misunderstanding of this. I always thought that when you were doing a temporary practice, it was like filling it in another optometrist's office. So it was dealing with a location which is registered with the board in one way or another. So, you know, I break my leg and I'm out of commission for 2 weeks, and Jeff says, "Hey, I'll work at your practice 3 days a week until you're better." So that's part of his temporary practice where he doesn't need a statement of licensure or anything like that. He's helping me out. Whereas if I'm setting up in a campground to see folks on a charity basis, that's not a location that's registered with the board, and I always thought that that was not permitted under this regulation. Am I wrong?
you are not wrong.
Okay, so if we're setting up at at the KOA campground and saying anybody who needs an eye exam because you were subject to a flood and you lost your glasses, you can come in and we'll examine you at this campground. And we don't have a van or anything on that order. We're going to set up an optometry clinic here. Is that legal if I'm doing that on a temporary basis and it's a location that's not on file with the board?
That is not covered within the law.
So I think, Jeff, that goes back to what you were saying. You want to set up someplace at a church or a public hall or something like that and do a charitable event. It sounds like if you're not doing it in a van, it's illegal and therefore potentially something that wouldn't even allow your malpractice insurance to cover you if there was an issue.
So Charlotte, when you say it's covered by the law, that means it's not necessarily illegal, correct? It's just not. It's not with. It's not just enforced.
There isn't a provision for that sort of practice in the law, and so it is the responsibility of the board to investigate any claims that are brought to us for practice that occurs outside of the law.
So, David, are you saying that setting up in the KOA campground after a flood does not fall under the temporary hours of work stipulation?
That's my understanding. But
I understand. I think I understand it as if you're not practicing in your normal location, not necessarily the fact that you're licensed as an optometrist. I'm practicing in your office. I see it as that I'm practicing outside of my office, regardless if it's whether in your office or at the school gym.
We have legal. Do we have legal counsel on?
Hi there, this is Danny Rogers. I would want a little more time offline to look into the set of facts that you presented before I offer an opinion on that. Unfortunately, we want to talk in turn on that.
Okay, thank you. Yeah, I just think we need a little more clarity around a few of these issues. It'd be helpful if staff can look into it, please. So if I also understand this, Dr. Garcia would not be able to go to the campsite or school under a tent. Dr. Garcia and Dr. Turetsky could only go into a mobile facility of some kind. Does it have to be their own, or they're allowed to go in and volunteer their time in another entity's vehicle?
If a nonprofit registers to be a corporation that can provide mobile clinics, and that mobile clinic, that van or trailer is registered with the board as a mobile clinic, then Dr. Garcia, of course, could give his temporary hours to, or Dr. Turetsky, to perform optometry services in that mobile clinic.
if it's registered.
If it's registered, that is correct.
Which would mean that, for instance, the Lions have a mobile clinic. They would have to register those clinics for me to work there to make it legal under 896.
Yeah, but doesn't it sound like it?
This is really sloppy.
So I know that the board had many conversations around wanting to make sure that we close this loophole in the law, and wanted to be able to bring, health fair organizations and, stand down homelessness operations within the law. The language of the bill, though, focuses narrowly on modes of transportation.
David, Dr. Turetsky, you cited the Lions Club, and I remember when we were working on this bill, didn't one of the exemptions that's set out in the bill under subsection B, would that not apply to folks like the Lions, or is your question more about I'd have to work for, I think the bill allows for Lions Club and such to be exempted from the parameters of 896.
Well, it sounds like from the discussion we're having, it sounds like a Lions Club van would be exempted. I would be able to work at a Lions Club van, but the way I'm hearing it now is that that van would have to be registered with the board, and they would have to go through all the procedures that are listed in order to make it legal for that van to exist and provide services. Or am I reading that incorrectly?
And to play off of that, so in the subsection B, it's not clear to me. The permit is for the mobile optometric office. But what is the relationship between these doctors who want to give care, whether or not they use temporary hours or not, walking in and delivering a service under this office permit?
So the way in which we work the regulation is that the relationship would be that the individual doctor would hold an SOL with the corporate address of that corporation. And then that SOL would allow them to operate within the permitted mobile optometry units that are operated by that corporation.
So Dr. Garcia, Dr. Turetsky, and all would now need additional permits and licenses.
Yes. If you were going to work with a service like Vision to Learn for extended hours, then you would need to register for a statement of licensure that says you do business with this corporation, and that SOL identifies that you may be working in the registered mobile optometric clinics that they have with the board.
Shara, this is Jeff. So that's only if you exceed the temporary hours of work of 5 days out of 30 or 36 out of 360?
Correct.
Okay, so Sharon, let me ask you another question on this, just to continue to beat this dead horse. An organization like Healing California, which provides optometric and dental services on a charitable basis, will set up clinics at different parts of the state, not in an optometrist's office, just at a meeting hall in a church, something like that. And they will provide vision care services and dental services on an as-needed basis to all comers, as I said, on a charitable action. Since they're not in a van, and they'll have optometrists work for them multiple times throughout the year, maybe less than 36, but does that potentially run into issues the way 896 is written? Since they're doing free exams, they're a 501c3, they're doing free exams, but they're not doing it out of a van.
I think that what might be beneficial for us is to, as we've just made this discussion here and we're documenting the minutes, to bring those particular instances to council and kind of look at essentially, if you are this sort of organization and you are doing this, then are we making a regulation for you or are we not? We are sort of getting into, the legal interpretation and looking at instances to understand who's covered and who isn't covered. And I think I've already misspoke once. So I want to stop here and make sure that we do sit down understanding this is a 501c3 and look at those exemptions with legal counsel in order to understand. I don't think that it prevents us from developing regulations here today and going into the meat of what we have for you. But I think that it does raise questions about what sorts of operations are still operating illegally, and then helping folks to understand what that might lead to.
May I also ask the chair to make sure that if we do have any members of the public that do anything from a charitable standpoint, make sure that we get their input on this now. If there's anybody on the call now, or definitely when we have the board meeting, but if there's anybody now, it might help us with this discussion.
Yeah, I'd like to hear, now that we've fleshed out some issues, if you will, and areas for further explanation, if we could have comment from the public, please, on these and others that they may have on their mind.
All right, this is the moderator, and at the direction of the committee, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment, please click on that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to allow the public time to access the Q&A panel and submit their requests. This is the moderator. It looks like at this time there are no requests for public comment. Would you like me to close the Q&A panel?
Please. I don't know that I would feel comfortable with an action other than having staff pursue some more information at this time. I don't know that we're ready to bring it to the board. And I would imagine that some of the stakeholders, COA and others, would have comments on this once we flush out a little bit more. In addition to probably some of the mobile optometric community. But I may be wrong, but I'd like to at least keep the conversation going and get these questions clarified so that we can bring it back to the committee and see if we get more comments.
Certainly, if we have the permission of staff to work with separately Dr. Turetsky and Dr. Garcia to make sure that we understand what these instances are, what organizations you are concerned about, and then we can also, hold some stakeholder meetings if they were not able to attend today or didn't realize that this would get into, this subset of the regulations. Then we can actively ask those groups to sit down and talk about their models and talk about what they do so that we might understand what perchance was missed in this.
And Dr. Garcia, your thoughts?
Yeah, I agree. So my concern is that there are some volunteer practice modes that don't fall cleanly into either 458 or 896 that I think need to be clarified. So I know a lot of optometrists do those sorts of things and probably don't even think twice about it. But now that we're talking about it, maybe we need to make that legal for them to do that.
And potentially build it in here or somewhere else. And that's
Correct.
where staff can come back to us with.
Well, we do want to make sure that our authority to create regulations is restricted by the statute. So we have the authority to make regulations for only those operations that occur within a van, trailer, or other vehicle. There's a truck, vehicle, or other mode of transportation, trailer, or other mode of transportation. Sorry. And so an expansion of that is not something we'd be able to do within these regs. That is a change to the statute that would need to be approached in another bill.
And or just clarity, if you can bring some clarity back on all of that. Dr. Turetsky?
No, I agree with all of this. We've got to get as much clarity as possible so people are not inadvertently doing something which puts their license at risk.
Okay.
Because no good deed goes unpunished.
And because we are sending this back to staff, do we need some type of vote on this? Or executive officer, are you good with just sending it back to staff, to the team?
That had been our intention today. Definitely. We know this is the first time that you've seen these regs, and I think it's important that everyone's still getting a good understanding of the law in order to create regulation in good faith. So I think that that's important. Is it possible, though, or have folks made any other comments or any other sort of realizations about the text of the regs that we have in front of us? Just because we are on that tight timeline, if there's an opportunity to get some feedback on what's in front of you today, we can move that forward along with answering the larger question.
Dr. Turetsky,
You
comments?
hold on. Hold on.
We'll move to Dr. Garcia.
Yeah, in terms of 896, I think I'm okay with the language. I know what the intent was. It was so we didn't have commercial optometric practices rolling around town. So I think the intent was to keep that type of service for charity type work only. I think this language does that. The only concern I have is how it impacts, like we talked about the Lions Club ban. How much regulation would they be under with 896 the way it's written?
So yeah, I think it'd be really important to understand what their business model is, so that we're then able to compare that to what's been outlined in the statute, and we can give you this is where we think this would be, but of course also bordering on the line of interpreting statute for a particular. So I think that we would want to take a look at this and try to understand, but we also want to be careful that we're not providing some sort of legal counsel to individual groups, because of course we can't do that as the board. The statute is the statute, but for us to understand what falls within the statute and what doesn't fall within the statute, I think is important to the work of the board and what sort of practice they want to legalize, and what sort of practice they think warrants enforcement.
And I know that we weren't prepared to bring something to the board for discussion on the exact regulations, but will we have a discussion on this tomorrow at the full board meeting? That is one of the agenda items, is it not?
So it is part of the regulatory update.
Shara.
Oh, I'm sorry. Am I back now?
You're back.
Awesome.
Yeah, you're back now. Will we be having a discussion on this tomorrow?
So there is the regulatory update that is the typical part of the executive officer's report, item number 5 on our board meeting agenda. I do believe that this is listed within the packages that we are working on. Let us try to do some quick staff work tonight and tomorrow morning to maybe give you a little bit of some of the answers you're looking for. And I think that it would probably be helpful, or I think it could be appropriate for the members of this committee to say, we went through these for the first time yesterday, but we have these questions about the law and what we're making regulations for. And so we've asked staff to go back and help us understand whether or not these certain types of organizations or groups are covered in the statute changes that were made, or if they are not. I think that's probably the most appropriate place, but we want to be careful to not go too far afield with something that's not on the agenda for discussion.
I think it'll also be good tomorrow too, because we'll probably have more members of the public at that point, and maybe we can get some input then as well. Does that sound reasonable?
Our board meetings are typically, more attended than our committee meetings are. So yeah, there's a likelihood that would be the case.
Okay, so moving forward, that we've gone through the regulatory proposal for the first time, and we have asked staff to research some specific questions as they relate to current practices, as well as the temporary hour model. Or were those basically the two issues? Are there Is there anything else? Because then we're going outside, I know, of the scope, but let's see what public comment has tomorrow when we have stakeholders there. Okay, thank you. We'll close out this discussion item then. So, are we good to go?
Unless there were any other comments that we can begin to work on within the text of the regulatory package, so that we just keep that moving along with the overarching questions.
Okay, thank you. And I think we're hearing that you can continue to move forward with what you have. We are looking for some additional information, but we're not stopping you from moving forward.
Excellent.
Okay.
Yes, thank you for the clarification.
You're quite welcome. All right, next agenda item. Let's scroll through. We can change our screen. There we go. Any future agenda items from members of the board, and then we'll ask for our friends in the public. Dr. Garcia?
None from me.
Nope.
I might propose Dr. Garcia's topic if it doesn't fit within this particular scope of discussion. How's that, Dr. Garcia? Because then we can get an answer.
Okay, that sounds great. Great idea.
Okay.
Thank you.
You're welcome. And lastly, motion to adjourn. I'm sorry, public. Does the public have any future agenda items for us, please?
All right, this is the moderator, and at the direction of the committee, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click that Q&A icon at the bottom right-hand corner of your WebEx screen. I'll pause a moment to give the public time to access the Q&A panel and submit their requests. All right, it looks like there are no requests for public comment at this time. Would you like me to close the Q&A panel?
Yes, please, if you would, moderator. Thank you. And last but not least, do I have a motion to adjourn?
Adjourn.
Second that motion.
And we're all in favor. Thank you, staff, for supporting us today and putting together a solid package for us to have a meaningful discussion from. We appreciate it, and we will see the team and/or hear the team tomorrow.
Thank you all very much for your time.
Thanks, guys.
Great job. Thank you.
Members of the public for joining us.
Bye-bye.